Hello. Over the past kind of 6 or so months, I've been involved in a few transactions between angel investors or kind of professional investors exiting companies here in Hong Kong. Those companies might be BVI or Cayman or Hong Kong. And there's been a number of issues coming out of the shareholders agreement that they've originally signed. So this session is a very quick summary of those key points so that you can look for them in the future. I always say to people, you're really worthwhile having someone independent look at your shareholders agreement. So when we go to it, first thing is, do all parties actually sign it? I'm surprised how many of these agreements aren't signed by both sides or by future shareholders, etc. You need to make sure that your access to records is enshrined in these agreements, especially if they're outside of your geography. So, having access to the books of accounts, if it's in BVI, is not actually very practical. You should be saying that they will actually be sent to you. You have access to the register of directors, the register of shareholders, charges, AGMs, accounts, anything you can think of, you should negotiate and you should put in there. Even if it's enshrined in law, I think it's worthwhile having in your shareholders agreement so that you got the shareholders agreement to actually talk to people about it. The right to appoint directors, and maybe even for certain people to group together and appoint a director between them. So by that I mean, if you're going in with 3 other people, maybe the 3 of you together, although you don't have a large voting block, you can appoint a director. Remember, being on the board enables you a lot of power in the company. You've got to consider what happens when shares are issued. Have you got a right to buy at the same price? What is the terms of that? How much notice they need to give you, and how are you going to be diluted? It's key to set out the frequency of meetings, the rough agenda of those meetings, what information is going to be provided. Just saying a business update is not necessarily enough. You should probably try and fill that out by a few bullet points to really flesh it out. Approval of key activities and changes. So changing the auditor might be something that you think a majority of shareholders should vote on. Changing the business direction, or selling machinery or intellectual property. And remember that if these things are the shareholder majority, what percentage is that, and what does that practically mean? Does that mean it's actually just the original founder, and this doesn't really affect you because you don't have the voting rights to change it? So work through all these things in your mind. Delivery of proof of investment. I've seen a number of people this year where they haven't received share certificates, and as we've done digging, it's been my suspicion that those shares were never actually issued. So make sure you get your share certificate, your note certificate, etc. Is an audit required? Somewhere like BVI doesn't require an audit under the company's ordinance. So if you want one, you should require one. And then very importantly, what happens in default? So if these meetings don't happen, if they don't give you access to records, what actually happens? What actions can you take? And they've already agreed on that you can enforce your rights. The shareholders agreement is the key document that you can hold up and say, I want this and it's my right. Don't just trust company law. Put it in the shareholders agreement. Have the shareholder agreement legally in your jurisdiction, so Hong Kong or Singapore, so that you can take management to court in a local jurisdiction and easily enforce these rights. That's it. It's a very short piece on a very big topic, but please feel free to get in touch if you've got any questions or if you would like me to look at anything. Thank you.